You know what song it is?
I'm going to throw down Eye of the Tiger.
You got it. And cross-examination, in many ways, really is, to some degree, that concept of being a silent tiger that's not showing off and making a big deal of it, but really have a keen eye to the evidence that's been presented, the discovery that you've gone through, and paying close attention to what people say. And you know, certainly having outlines and all that stuff, but ultimately really kind of paying attention to the words that people use. As before, I'm honored to present with Judge Voluck this morning, and it's too bad you don't get a chance to meet him in person. Maybe in the future you will, but just a really good-hearted individual, and I do feel honored to present with you this morning, Judge. So thanks for being present, even though it's 2 hours earlier where you're at, so I've had a little more time to wake up.
Mm-hmm. Well, if I had to start off the day, David and David's all right.
Yes, yes.
Let me just say, David, I have one quick thing, and I know we have to be economic, so you'll have to guard me. You know how I get. But I'm so happy to be here, actually, because I did a taping of direct examination.
Oh, nice.
And I was like sad. I said to the class, man, whoever got cross exam, they're the lucky ones.
Yeah.
You know, because direct's so important, but it's not as exciting. So I love your soundtrack.
Yeah.
And the metaphor of the tiger. And I thought about it, and cross exam is probably one of the more fun things or thrilling things that you get to do in this business. So I'm really psyched to do this with you this morning.
Awesome. I am too. And I would, you know, I think it's relevant, and I know we'll finish in time, so I'll just say that, you know, it's a reminder too for, we had a conversation prior to the presentation of everything to me in my job and everything that I do, integrity is everything. And, you know, right now we have a system on many levels, but, you know, you look at the federal court system and Department of Justice, and we rely upon them in so many ways because they are the overarching government and law enforcement agency that handles the rule of law in our country. And, you know, when you start seeing the integrity being jeopardized, I think it only means more so that on our levels of the work that we do, that we protect it and we fight for it in every way possible. When I see compromised, you know, I mean, basically when you have offices getting people fired because of investigations that they're opening up, or trying to do the right thing and then losing their job and losing that opportunity to do and to protect the integrity of our system, certainly raises a lot of red flags. I think we're lucky that the Supreme Court has actually had a couple good decisions in recent time, but still gives me great concern. But kind of like you were saying earlier, Judge, about our individual responsibility in finding peace, you know, I think the same thing applies to the rule of law, in that we have an utmost responsibility at being truthful, being fair, and protecting that rule of law, and not compromising it by coming up with things that you don't believe to be true. And if you can do that as an advocate in this field, I think you'll feel a lot better about yourself. I can say wholeheartedly, without question, I've never had my integrity jeopardized, and I've had plenty of cases against individuals where I know for a fact that they had to jeopardize their integrity to try to protect their client. And that's a tough job, and that's a tough way to go to sleep at night. And I think there's ways to do it where we protect, you know, our moral compass. And so when you're doing this job, you know, you've always got to make sure that's part of your process, in my own opinion. So.
Amen. I'm just gonna dovetail quickly and say, as we talked about earlier, it's the overarching justice system can be disconcerting and leave your sail without wind in it at times, you know, deflated, I guess is the word. but it starts at home. So we might be working in small tribal courts and small little corners of the earth of justice. But there's a great saying, tzedek, tzedek tirdof, justice, justice you shall pursue. And so that oath is on all of us. And if the big shots are losing their compass, then it's up to homegrown cooking and organic vegetables, from the small justice systems. There's two ways it's called the trickle down theory. How about the trickle up theory?
Yep.
That we start at home and repair and hold our integrity and the justice system and trickle up to the big suits, that, hey, get back on your way here.
Absolutely.
Yeah.
And for cross-examination, just a few tips before we get into it, and there's gonna be a lot of information presented to you, but a couple things that I think of early on is one, preparation is so important. And preparation doesn't mean just coming up with a list of questions. Preparation means going over your evidence, going over testimony of your own witnesses that will be testifying, going over the information that you have regarding the other witnesses from the other party's case, and knowing the statements that they've made in the past, and then coming up with an outline. And I say outline because outline is definitely something you want versus a list of questions. Your outline could have a few cues as to what kind of questions you want, but ultimately a lot of your questions are going to be based upon how that person testified during direct examination. And so, just so you know, as you probably already do, the process here is that if you're a plaintiff or if you're a prosecution, the pueblo or tribe, you start off, and if you're calling your own witnesses, you're doing it upon direct examination. And then the defense gets to cross-examine your witnesses, just like when it's the defense's turn to put on their case, they do a direct examination, and then you in turn get to have cross-examination. Personally, I think that you're focusing on not having a lot of questions, but more so kind of having the right questions that you want to answer, that you want answered. And you have to know who your audience is. Is it a jury or is it a judge? And you'll certainly, if it's just a judge, you're going to be able to tell just by starting your line of questioning how interested they are in this particular witness. And at some point in time, you may see them dozing off to the extent that you're boring them. So just being mindful of who your audience is and what they're expecting to have happen during the case as well. If it's something that does not help your case, or if it's a witness that has no credence to your case, those are decisions you have to make, whether or not you even want to cross-examine them. Maybe they made themselves look a little foolish on direct examination, and you pass on them on direct. An example for that would be, I called a doctor from UNM Hospital in a strangulation case to talk about the damage to the carotid arteries and to the jugular veins and all that stuff from a strangulation case. And then there was an expert on the other side that spent his time talking about hickeys and how hickeys can leave certain visible injuries that are consistent with strangulation. And he was so bad on his direct examination, and our doctor was so strong, and that it wasn't even worth my time to go through this process with him, especially when he probably is more knowledgeable about these issues, because he could come up with anything to phrase medical terminology to favor his client. And so for me, knowing how strong the testimony of our expert witness was, I pass on the cross of that doctor. And so those things will come up for you. You have to make those decisions as they happen. But just knowing when to actually exercise the right to cross-examination is definitely something to think about too. Yeah. So going, just to start off here.
Could I jump in for a second, David?
Yes.
So David made a couple of key points that I will try to keep in mind as well. So if I'm not only a client, I'm not only president of Air Club, I'm also a client of the National Tribal Trial College. There's a famous saying in sports, you can't teach touch. So having a nuanced idea of your case and strategy is important to being a good tiger. So And especially as you start, like I said, this is the most thrilling aspect of practicing any kind of law, is to pounce like a tiger. And David's point, which please don't, gloss over, is know when to walk away from the car. You don't have to pounce on every piece of meat because you're a tiger. And in David's situation, he was able to realize that Cross, even though it might have been easy pickings with a hickey, really, doctor, we're talking about hickeys. He
Yeah.
didn't have to do that, even though it would have been fun, maybe,
Mhm.
and thrilling to take down Dr. Hickey. It was going to actually backslide his case, and it could have opened doors to things that he didn't know what was going to happen. So if someone does not do an effective job and it comes to you, the judge will say, counsel, cross-examination, know how to say, no, thank you.
Yeah.
And there will be times also, say, with respected elders and things of that nature, where it's a no-win situation. And crossing for crossing's sake is not recommended,
Yeah.
you know?
Yeah, and I think, and I know that we're spending time on this, but I think this is just as valuable as the slides. And so I think, and that also applies to the idea that I think there's a misconstrued mindset that we have to get them to tell the real truth of what happened. We have to get them to admit on the stand that what they said was a lie or what they did was wrong. And certainly that's a great victory and a great goal. And it doesn't always happen. In fact, it's a rare occurrence when you get somebody to actually admit to those things. But I look at it as like a stairwell, and there's a door at the top of the stairs, and you don't know what's inside that door. And you're leading that jury or that judge up the stairs. And by the time you get them to the top of the stairs, you don't even have to open that door to get them to admit, because your cross-examination was so effective that they already know what's behind that door based upon the answers that were given without them actually admitting, to I stole the Twinkies from the grocery store, whatever it might
Right.
be. So think of it
Yeah,
as that
may you
stairwell.
all be blessed with aha moments where the witness breaks into tears and says, "You were right, I'm sorry."
Yeah,
May you have those moments, but don't
absolutely.
expect that to happen.
And another key thing too is to not to get stuck in situations where they're not answering the question where you thought that they should answer in a certain way. And an example would be, in one of my first federal trials, I got stuck on and it's the hardest cross-examination as a defendant. It's the most exciting, but also the most difficult. And the defendant was on the stand, and we were talking about the consumption of alcohol, and he had consumed a 12-pack at Budweiser. And my focus was going to be on, him being intoxicated about how much he had consumed. And at some point he turned it on me and said, "Oh, so you think I should be intoxicated by a 12-pack? A 12-pack for me is just getting started." And the jury and audience kind of giggled a little bit. And it was embarrassing, right? Because it was just him coming up, and he laughed, and it was probably totally disrespectful. Everybody else laughed, but the way he came across saying it, for a room full of people that might party once in a while, I was like, "Oh, that was kind of funny." And you don't want to have that kind of response happen to a defendant that you're cross-examining that you want to make foolish. He came across funny,
Right.
So you can have some really bad things happen if you spend too much time trying to get them to say what you want them to say. If you find early on that they're not going there, move on. Don't spend too much time, because a jury's going to recognize you're trying to get them to say something they're not willing to say.
Amen. Yeah.
Which means theatrics, right? I mean, I think it's so important, and everybody has a different thing. I'm a very natural person when I do this stuff, but I have been in the courtroom with prosecutors or plaintiff attorneys that make it a point to have some type of theatrical performance or some type of moment where they slam the table or they throw a paper across the table. And For some it works. For others, I've met with juries after, and they said, yeah, your co-counsel looked terrible and was way too arrogant when they were presenting, evidence or testimony. And so I guess, there are times where you want the jury to see that's an important moment, and maybe you lean forward in a certain way, and maybe you even kind of shake your head in disgust based upon something that happened. But don't make it a point to make theatrics your whole performance in the case. So just another little tidbit. Moving forward here, the purpose of cross-examination, as you can kind of tell from our discussion already, is to discredit an adverse witness, which means a witness that is not a witness that is on your witness list, but a witness that's helping the other party or testifying to something that doesn't support your case, to lay the groundwork for closing argument. And essentially what that means is that the testimony that you have from somebody during a cross-examination, that testimony and the information that came from the testimony can be used in your closing argument because it is something that happened. You have to remember that when doing your closing, you can't come up with things that didn't happen. You can't make statements that weren't made at trial. You have to use factual evidence that happened. And, so part of that is pulling from your cross-examinations. If you had an effective cross-examination on it, you want to put that in your closing argument. And to demonstrate control of the adverse witness and the courtroom. Part of that is me talking about the theatric side too as well, but also, it's your preparation. It's the logic that you used in doing your cross-examination. And it's taking your time and not running through it and feeling like you need to get through your outline as fast as possible. You have control of that situation. You are ultimately responsible for how quickly that witness testifies and what they testify to. So you learn what kind of pace that should be. And that's how you kind of control the witness and the pulse of the courtroom too. I'll jump in just one more time, Judge. So what is cross-examination? Cross-examination is a form of questioning through which the questions bring out good facts or negate bad facts in a case. The big distinction between cross and direct is the use of leading questions versus open-ended questions. And when I think of open-ended questions, I think that it's really the what, why, and how. How did that happen? That's giving somebody the opportunity to tell you a story about how something happened. When did that happen? Oh, it happened, at this time and this date, versus it happened on March 24th, 2020. Did it not? Yes. So the difference is really whether or not you want to lead them with the answer. You're from Albuquerque, New Mexico versus where are you from? And so just remember, for direct and cross, you're not using those what, whys, and hows. There's a very limited avenue as to when you want to open the door to potentially open-ended question, because maybe you're doing so well and this person is spewing such garbage that you want them to continue spewing garbage because the jury is not buying it or not liking it. Then throw a few open-ended questions in there. Otherwise, you want to be leading your witness all the way through it. That's the beauty of cross-examination. You entirely control exactly where this person is going by answering the questions for them to the extent that they're just saying yes or no.
Right. And it's a trick to teach your brain this. It's like a bike riding trick, how to pop a wheelie, but you'll eventually, and I'm 50 now, David, and I still get crossed up in my mind. But the direct is an open-ended, tell me what happened, and a cross, you get a formula of words. The trick is, isn't it, or like you said, isn't that true? At the end of your sentence, just you adding those 3 words turns it from an open-ended, and a good lawyer, I'm not as good as I would like to be, but a good lawyer is the one testifying to the facts, and all they have left is a yes or a no.
Absolutely.
Yeah. Oh, well, look, here comes the slide.
Oh, yeah. Yep. It's recovered.
Yeah.
But I haven't, yes or no. So like just the judge said, in the last part here says, we kind of gone over this, but you're ultimately hoping for a yes or no answer. And if the person doesn't answer it that way, you could stop and you could ask the court, Your Honor, will you direct the witness to answer the question? And that is a way to get the person from rambling on about something unrelated, but focusing. It's a yes or, and you could even tell the witness, Mr. So-and-so, this is a yes or no question, yes or no. And if they continue, Your Honor, will you please advise the witness to answer the question? So that's kind of how you handle a situation where they may not be doing kind of what you are expecting them to do. And then if the court has to admonish that person and tell them to answer the question that's being asked, that's also kind of a good cue for a jury to be like, ooh, they're not, the judge had to intervene here to kind of get that witness in line. So also,
and particularly in the domestic violence arena, oftentimes the protective order process is a judge. So if the judge needs to admonish the stray sheep, or if they're an intelligent batterer, they're using their time on the stand to get their narrative out again. And so when you're trying to keep an adverse witness is not your friend. So don't think you're going to have a conversation with an adverse witness. If you're trying to keep them in line and they keep veering off to get their point across or their narrative, you, as David said, ask the judge for help. Your Honor, you can give them one warning. Say, like he said, this is a yes or no question. If they keep veering off, that admonishment from the bench is a pretty powerful thing, particularly for batterers, because it puts them in their place,
And one of the things that we kind of lose out on by not being there that I want to remind you of too is that don't, like the judge said, he's 50, you're 50 years old, Judge?
Just turned 50.
Oh, happy belated birthday.
Thank you.
Is that just like the judge, I mean, I will go into court and maybe I'm good at looking confident, but I am probably nervous and scared to my wit, even after doing this for a while. And number one, I think it makes me better, but that is a natural feeling that you're going to have. And do not expect yourself to be a pro or a champ at this in 1 or 2 trials or 3 here, whatever it might be. It takes time and practice. And even 13 years later, you still will have the butterflies. And the way that I personally have attacked those butterflies, for as silly as it sounds, and this just comes down to doing research on it, because I used to be a person that would get up in front of the crowd and get worried about passing out because I was so anxious, is I had a little black book. And in that first page of the black book, I had 10 things about myself. You kick ass. You've done this before. You are good at what you do. You care about what you do. People listen to you, and you do all those things, and I'd read them, and I'd read them, and I'd read them, and then I go straight in there. And then I would do the old 25, I would count 25 breaths. And what that does is it gets you to focus on counting your breaths and doing it in a nice pace versus having your mind go in 50 different directions and be all nervous. Instead, you focus on one thing. And so then you do that and you walk into there in that process right after, and it helps tremendously. So just a few little tips that I use.
I'll give you one of my KG street tricks. And yes, you are correct. After doing this now 25 years, when I'm done, I still need to wring out my shirt from the sweat and perspiration of being anxious and nervous. My street trick was, I realized I was going to need to speak in front of people. So I had to address this anxiety that you're talking about. I'm sure mine's a different brand of yours, but it comes from the same well.
Mm-hmm. Yeah.
So what I did was I took any opportunity, David, any opportunity to speak in front of a crowd. And if it meant teaching nursery school to 3 and 4-year-olds, that's the job I took. Volunteering in my kids' class to talk about X, Y, or Z. Any presentation, no matter how small, I'd take it, because dang it, anything in life, practice, practice, practice.
Absolutely.
And after a while, you start to find that rhythm. And then when it comes time that you do have to give a speech or you have to give a closing argument, you've been on that bike. Even if it was teaching nursery school, you're on the bike.
Yep.
Yeah. So,
which is another good tip from that, is that if you have a trial coming up and the judge is in the office next door to you, or you have a colleague next door to you, you know, you work together on these things. You know, you take the time to do a practice run through, right? I mean, you have them take the role as a witness, then don't ask them to say anything. You just go through your lines of questions with them and practice your questioning with that person and how they respond. So don't feel like you have to do this on the cuff. Definitely practice these things in your cases. I mean, I know trial attorneys that will do, you know, practice opening and closings and all that stuff with their colleagues before a big case. So
Yeah.
here's a whole list of examples of leading questions. An example, and in fact, I'll start off here by doing a how you would do it on direct, and just to remind you how you switch it.
Good.
Mr. Walker, approximately how much do you weigh? Open-ended question. You want them to tell you. Mr. Walker, you're about 260 pounds. No, I'm not. Are you over 260 pounds? No. Would you say you're over 240? Yeah. You know, if they're not answering it the way you want to, you can rephrase it a little bit. Your wife, Shirley, she weighs 160 pounds. Is that correct? Yes. Mr. Walker, you're 5'11". Shirley is 5 feet tall versus, Shirley, how tall are you? Where do you work, Shirley? Oh, Shirley, you work out of the house, don't you? Shirley, where do your kids go when you go to work? Oh, they blah, blah, blah. Shirley, your kids stay home with you when you work. Is that correct? Yes. You've been arrested for domestic violence twice. How many times have you been arrested for domestic violence? That would be your direct question, and how you switch that, obviously, is you're answering that for them. You know how many times. You have the conviction. You have the arrest record. You've been arrested for domestic violence twice. And then if they say no, what do? The first thing I would do is I would say, is it not true on December 12th, 2019, you weren't arrested for domestic violence when you battered your wife at the home located within the Shoshone Reservation? Yes or no? You know, and if they say no again, Your Honor, may I approach the witness? Do you recognize this report? Yes, I do. Does that include your name on the report? Yes, it does. What does it say?
Well, hold on, David. You slipped. That is your name on this report,
Yeah.
isn't it? But you see how hard that is to keep that bike trick of popping the wheelie on the closed question. But yeah, you're doing awesome, by the way. But I saw you start to slip, and that's good for the students to see.
Absolutely.
Yeah.
So the point being is going through that and looking at all those and how you would ask those in direct and how you quickly switch that to be a leading question on cross-examination. So this is a good go-by for you to use to look at when you're doing your crosses and just kind of get an idea as to the various ways you can ask these questions and do them in leading form as well.
Right. But David's example is really good because he dug himself a hole by not playing nicely and lying. And you've got 2 police reports. And so he thinks he's being fancy at first by playing with you, fighting with you. And as an advocate, you should know, go, brother, go. Here's the shovel. Because by the time David has approached him with these police reports with his name on it, he looks like a fool.
Yep. And that's a good reminder of to have your evidence binder, or at least no evidence has already been presented, so you can pull from those things and use it to contradict whatever false statement they gave to the court or to you during your cross-examination.
And practice tip, Judge V used to have a pile of papers on his desk. And that's not the smoothest when you're like, hold on, I know it's in here somewhere. And you're shuffling papers on your desk. Talk about a wet shirt. So the idea of the binder, which I think Cousin Amy talks about as well, priceless.
Good point.
Yeah.
The jury wants to see an organized attorney, and they want to see you put together. So yeah, you'll hear from Amy, and that is the trial binder is a necessity in all of these cases, in my opinion. Cross-examination is not discovery. What is discovery? Discovery is what should have taken place prior to this point. If it was a criminal case, remember, and if you're working on behalf of the tribal government, or maybe you are a lay advocate, prosecutor, for me, discovery meant an open book. I did not withhold anything, even if I had the ability to do so for a longer period of time. And the reason why I didn't is because the federal level and the judges were not very kind to prosecutors, and it could ruin your career if you were a prosecutor that withheld material that could have been deemed relevant or helpful to the defense over the long term. I did not want to be the person that decided that. I felt like the defense attorney should be the person to know whether or not that's helpful or not. And so when it came to discovery, I was an open book, with the exception of redacting personal identifiers that we had the legal right to redact to protect their identity or their whereabouts. Otherwise, that's discovery. In the civil side, discovery is you filing requests to inspect documents and to produce documents and to have interviews where you depose witnesses. And so that's the discovery that should have taken place prior to this point. You better not be going in there. You don't want to be going in there not knowing the possible answers to the questions that you're asking. You should have a pretty good idea how they should be answering the question that you are asking them on cross-examination. Why is it not an interview of the witness? Because, you know, the interview of the witness is more so what happens on direct examination. You're giving them an opportunity to tell a story, to tell more about the situation, expand upon it. You really get to limit here what they say and how they say it. Because really, like Judge mentioned and the slide pointed out, we're talking about yes or no answers. And so again, same thing. You know, you're not having a conversation here. This is really about getting to the top of the stairs so the jury can see what kind of door you're trying to open.
Right. If I could sum up this slide in 5 words or less, it is, you know, there's a maxim not to ask a question you don't know the answer to. So, like I said earlier, don't use cross as a tool to ask a question you don't already know the answer to. So all these things are saying this person is not your friend. They're an adverse witness. So you're not chit-chatting about something you want to know about. You need to already know about it. And it's rare that you can lob a cross exam that you don't already know the answer to. So be very careful, young Jedis, about taking a chance to try to find something out on cross-examination. It's not that tool.
You could ruin your whole presentation of the witness just by a simple mistake such as that. We talked about this.
So here we go.
Yeah. You want to take it, Judge?
Oh, well, we already warned you all.
Yep.
Being a tiger is cool, but hunting is dangerous. So don't jump on every piece of cross-exam meat that comes your way. And also try not to take your cross-examination skills home to your significant other, right, David?
Oh my God.
Because us little advocates have a little problem with relationships when we start cross-examining our significant others. So whatever you do at school and at work, try to keep there. That's advice number 1. But also know when to walk away from the car. Like I said, it's a thrill. It's fun to show someone when they're being silly or lying, because lying also violates us on the inside, David. You know, that little conversation we had before we started class. A lie drives all of us crazy because there's such a thing as truth. And we grieve when we break the truth ourselves as well. But that's a whole long story. The point being, why was I even saying that? Know when to walk away from the car. And here's another very important practice tip. Sometimes the courtroom can become catharsis for our clients. And they will want you to show that their mother is a liar. okay? And this is a personal thing that's been bothering them for 10 years. And now finally they have a lawyer and they want you to cross-examine their mother because she's a freaking liar. You will do it. And you, as an advocate and also a counselor, need to recognize if it's actually a strategic mistake, you're going to have that come to fill in the blank talk with your client about, I need to tell you this, that I hear you, I feel you, be empathetic, but cross is not that tool to get revenge or to finally expose someone to be the sham that they actually are. You know what I mean, David?
Absolutely. It makes me think of the late, great Kenny Rogers. You've got to know when to hold them, know when to fold them,
Yeah.
know when to walk away, know when to run. And so I humbled myself with my poor voice, and I would just say that's a good
No,
reminder.
I appreciated that because it took me, I was young and full of piss and vinegar, and there was no way on God's green earth I was going to pass on a cross exam.
Yep.
And as the gray has started to fill my beard, I realized, calm down, Tiger.
Yeah.
Do it right.
Do it right.
Oh, will you go back to that previous slide? I want to make sure we didn't miss it. Yes. So we've already talked to you guys about that stuff. Yep. Thanks.
Yep. So this is a good slide that really outlines your whole, not just your tips on how to do a cross-examination. This is something that you should have started thinking about on day one. And when I say day one, the way that I used to work, especially in the criminal setting, is I started developing my theory of the case right away. And then so everything that happened thereafter in the collection of evidence was either information that came in that supported my theory of the case or it didn't. And I would divide it accordingly. And I would decide how that would be useful during situations such as cross-examination. So really, I mean, really this is coming down to how well do you know your case and how much homework have you put into this case and how much does it mean to you? And, you know, you will come to a point where you are so busy that it is going to consume parts of your life, and you will find yourself anytime I had a trial come up. I mean, it was at the time I was married, and it was one of the probably most difficult periods of time for, you know, my wife at the time, because you're coming home and I was living and breathing the trial because there wasn't enough time to prepare. It was always, you needed every minute to prepare. And like Judge said, I mean, this is a tough one. I mean, I think it's a really good, important thing to do is when to turn it off, because you start having conversations with family and friends. In a second that some gray area popped up as to an answer that somebody's given, you need to find out the black and white side of it. So you start asking questions and you sound like a goddamn prosecutor, you know, and it's definitely not appealing to most people.
Did you take a bath or not? Answer me.
I know. Oh, Lordy. I mean, there's been a lot of those conversations.
Yeah. So I guess we should have another session on work-life balance.
So true. So true.
Yeah.
I'm sure my 12-year-old daughter has a real field day when it comes to me having explained to her what the truth is and how answers to that can, you know. So she holds me to it though too. She'll cross-examine me now. She's good.
That's right. Be careful what you teach.
Yes. Use one fact per question. And what this means, and I think that the objection to this is a compound question. And if you ask two questions in one question to the witness, you're probably going to get an objection from the other side. It's either confusing or, Your Honor, compound question. There's two questions in this. We're not sure what they're asking. So if you can focus on having single questions, that's definitely the way you want to go.
Yeah, and I would say if we were there in Wisconsin, and ideally we'll figure out a way for you all to practice, that what David just said will be, again, it's mental discipline to teach yourself one fact per question. because your brain is moving fast. You know the story because you've done a lot of homework, and you'll shoot out. The image that comes up to my mind, David, is when you're trying to skip rocks on a lake, and that rock hits like 3 or 4 times. So our students often, and myself, you'll shoot out like a machine gun 3 questions. Well, isn't it true that you opened up the car and then did this and then did that, and it's confusing, and you'll raise an objection for compound. Breathe and
Yep.
start to train your mind one at a time, very methodical. And it's hard. It's like that bike trick.
And if you screw up, like the judge said, breathe and take the opportunity. And this is what you say is, let me ask that again. Or let me be more clear about my question. Let me try that one more time. It could just be
Right.
as simple. You don't have to create this fancy legal language. Just let the court know and the witness know. Actually, it's strike that question. Let me re-ask that question once again.
Sure. And I will say that I've taken to this, and this might take time, but I apologize to everyone. Sometimes like, yeah, that was a confusing question. Let me try it again.
Love
If
it.
you're human, everyone's putting on their pants in the morning. And so if you're just like, yeah, wow, that wasn't my best question, let me try again, everyone relaxes, and the beautiful oops moves along, and you just go again.
Yeah, and going to the plan to start and end strong. I guess my best analogy for that is the way of thinking of it is kind of my stairwell analogy. You start at the bottom step. We don't know what's behind the closed door and the top, but the idea is that each step you go forward, you're supporting your case. By the time you get to the top, you don't have to open that closed door. We've covered a lot of this.
Yeah.
Open-ended questions begin with who, what, why, where, when, and how. You heard me contradict this slightly to the extent that I did say if you find yourself in a situation that you can ask an open-ended question, and it says always ask leading questions on cross. I mean, ideally, you definitely want to be always asking leading questions on cross. Every blue moon, you're going to come across a situation where somebody can't help themselves and you find themselves digging themselves a hole. And if you have set that up perfectly, that's your little single opportunity to allow them to continue rambling, ask an open-ended question. Go ahead and explain yourself, whatever it might be. But again, you could be playing with fire there too. You might open it up to where they say something that it's going to hurt you. So you're taking a risk there as well. The more control you have, the better. That is going to be, like I said, that's a very limited area as to where that would happen.
Right. It's probably advanced litigation there. So it's like a special move in whatever sport. Don't always go to the windmill dunk. Like start with learning how to make a layup. And it is amazing when it happens. Sometimes, the good Lord smiles and someone will open Pandora's box, and you did all the homework in the world and your eyes go wide open. What did they just say?
Yeah.
But it's a rarity, so don't go in thinking that's my move.
Yeah. And it may be, and here's an example of where you think it might be good and it might be bad, and it might turn out bad, is that let's say that you've gotten a mother-in-law to have a cross-examination where by the end of it, it's really clear she just completely despises the victim in this case. And you've got, the jury knows that, that, it's clear, you could tell she's got a cold heart regarding her. But at the end, you just want to know why she does. And it's like, I could tell that you hate Jane Doe. Why do you hate her? And it's because you've already got her to appear as if she hates her. And then you open it up and maybe you're thinking that she's going to tell the jury, oh my God, she does hate her. And she's going to say these things. But then she says, well, I've watched her hit the child in the face 5 times. I've never liked her since that happened. And all of a sudden this situation that you never knew that your client had hit the child 5 times, and you opened it up to have her give all this information that you weren't prepared to hear, and either was the jury, and all of a sudden your awesome case just got crashed because you allowed this person to just ramble on about their personal opinion, which may not be true.
Mm-hmm.
Well, and that was,
More of the same. Danger, Will Robinson, danger.
yep.
Uh,
And this is exactly, I mean, may not have been the best example, but it kind of gives you an idea of what direction it can go, because you didn't know where it was going to go. You just know that she hates her, and just her hating her is enough. If you know that, the jury does too. Why go down a different avenue if you don't know what the outcome is going to be? Don't ask the witness to repeat direct examination on cross. This is an example where you could have the other opposing party and their attorney get up and say, asked and answered. That question has already been asked, Your Honor, and it's already been answered. And so the judge could say, counsel, move on. And basically, you know, sometimes attorneys will want that person to continuously repeat an answer that may be serving to you, but in doing so, you might get yourself in a little bit of hot water with counsel or the judge. Most counsel is pretty fair about this stuff, you know, but when it comes to cross, you will definitely get them objecting more. And it doesn't even have to be a named objection. It could just be an objection, and they'll approach the bench sometimes, because sometimes the judge will want to hear what that objection is, and understand better where counsel is coming from outside the presence of the jury, and they'll have a discussion, and then the judge will make a decision thereafter. So that's kind of how that plays out. It's dangerous to ask questions that you don't know the answer to. We also covered this in the beginning when I mentioned to pace yourself. I think one of the fundamental rules when it comes to cross-examination, in addition to preparation, is having a good pace, talking slow enough. You remember that you want to be clear, you want your questions to be clear, you don't want the witness to be confused, taking your time through each question. Once they answer your question, I mean, be looking at them. Don't be looking at your next question. Hear their answer to make sure it was answered the way you thought it was going to be, so you don't have to go off and do an additional question, so you better understand what's going on. So really be careful about listening to what they say, because what they say may lead to you asking an extra leading question regarding a situation.
So I want to highlight what David's saying, and this is normally a practice tip I give in Wisconsin, and it is listen, listen, listen. Okay, you're going to need, when your adverse witnesses are testifying, you are going to need laser focus to everything they say, because they may open a key to something very delicious. And what happens, the only, beyond practicing your listening skills, the only thing that will mess you up but good is your client sitting next to you, whispering in your ear that they're lying. They're lying, and this is what happened. I was there at the supermarket, and then, and I cannot tell you how important it is. You need to have a way to manage your clients' busy bee in your ear when you are trying to be a laser pointer on everything these people are saying. And so a key thing is a pad of paper, and please calmly write down your comments, and I will read them. And you can explain it to your client. This is for you. I need to listen to this person. And you've got to break them of the habit of them breaking your concentration while you're doing this.
It's a tough one. I think we've covered that one as well. Don't ask one question too many times. If it's a situation where you realize your question isn't making sense or there's too much confusion, doing what Judge said, I apologize. I'll move on from this question. Whatever it might be that's smooth, but being honest about the situation. But ultimately, you're going to get an objection if you've asked the question multiple times.
And, the hard part, and we'll do this, I think, when we practice, is when they're lying. And they're lying. And so you're just you get obsessed with asking that question over and over and over, and they're lying, okay? But it turns into a pissing match. And I don't know, David, you tell me. I've never really come up with the magic wand for someone who's just a bald-faced liar. But maybe I'll ask it twice, and then I don't know if this is too heavy-handed. One option is to say, are you sure you want that to be your answer? You know, or are you sure you do realize you're on the record right now and have taken an oath? Are you sure you want that to be your answer? And if they double down, I say, okay. And then that's that. You can come later with a rebuttal witness or some other thing, but not to get into a tug of war with someone, but that maybe there is a way to back away from the car noisily, that the judge or the fact finder, they have just seen a flag that there's a problem over here. How do you handle that, with like a liar?
I actually think that your recommendation is the best one. Number one, you definitely don't want to get in a tug of war. I mean, because if they're coming across as a liar already, and if you've proven your point that they've lied through their testimony, you're not going to necessarily always get them to admit to such, and you'll get into an ugly battle by doing so. And the jury is going to end up focusing on you looking too strong-handed or maybe being unfair. And so I think the way that you mentioned it, Judge, where you end by saying, prior to testimony today, you did take an oath to swear to tell the truth, did you not? I did. And you're telling the court now that the statement that you give to blank question was the truth? Yes, I am. And if it's that clear that, that the person has just been lying or misleading the court, and then you kind of make that face and say, no further questions, Your Honor. And you just kind of move on.
Or
and like
move on, yeah.
Okay.
Judge, yeah.
And then you can use a rebuttal witness, or then you can, maybe you have another witness that will contradict what was stated, or you've already proven that they are a liar. So you don't need to have them tell you that they are a liar. You probably have already done it at that point. If you're asking the question, did they take an oath to tell the truth?
Right.
That's a powerful way of doing it, because it's a way of closing it up, reminding the jury that they swore to tell the truth. And you're basically saying at the end here that they're not telling the truth by asking them if they took an oath.
Right. So you're backing away from the car, but it's a noisy exit of, that's a lie. Okay, moving on. Yeah. That's all I've come up with. I don't have a magic wand for those hard people.
Or another way of doing it would be maybe the brother of the defendant makes us, I'm trying to think of a situation here, but somebody's making a statement that I know for a fact that this never happened. And that's what they say. I know for a fact this never happened. You weren't in the house that night, were you? No, I wasn't. Were you even across the street from the house that night? No. Could you even hear anything from where you were? No. But you're telling the court now that this never happened. No, it did not. So, I mean, you can kind of play it where whatever it is, you could use to your advantage. This person wasn't even there. They're just giving a statement that this never happened. Prove through your line of questioning that they could not possibly know by showing that they weren't even there. So that could be another way of just countering where they're saying it's a fact that this never happened. How can you prove otherwise that this isn't the case, and maybe this person wasn't in the household, so you can just attack them in a different manner.
Right.
I think Judge has pretty much covered this. We both have, in just the sense of, I think one of the things that the judge said is being human is extremely important, and being humble is also extremely important. It's okay to acknowledge mistakes if they are made. That's just showing a jury that otherwise may not trust attorneys and thinks that all attorneys are liars, that, oh, this person's being honest about making a mistake. This is a good person doing this. Being professional at all times. I really struggle with people that have too many courtroom antics and doing too many things that appear to be part of a show. But the flip side of that is some people love it. So I don't know the right or wrong answer there, other than I like to be calm and professional. I think if you're passionate about what you're doing,
They just love it.
yeah. I mean, wow, I've seen some stuff, and it's like it makes me cringe, you know.
uh,
Um, don't expect any aha moments, and I think that is awesome advice, because if you expect aha moments, you end up going and asking way too many questions and getting way too far down the line and across, and you lose sight of where you're going with it because you're looking for that single aha moment. And your goal should really be having the aha moment be the finishing of your 6 questions, and you've led the jury down the path that you want them to be down, versus getting the person to say, I did it, I can't take this anymore. You can't handle the truth.
yeah, and the piece about in your face is you run the risk of you ending up looking like the bully, and it's a bad look. Let's put it that way. Is that a fair statement?
Yeah, in state court versus federal court, like in state court, you might have a situation where you have the podium right here, and all of a sudden you'll see the attorney deviate from the podium, and they start approaching the witness, and they might get right up there and put their arm right on the thing there, and they kind of get in the face too, where it's actually a physical interaction versus just the verbal communication, but they're really driving home on how badly they want this person to feel, whatever it might be. Versus federal court, the judges do not like you leaving the podium. They don't want you to be unmiked. They want it on the record. They want you to stay there. That's part of the professional decorum that they want in the court. And so kind of knowing your form is also important in terms of what's permitted and what's not permitted. But avoid being that person that looks overly arrogant and trying to cause almost a verbal dispute with somebody on the stand. Makes you guys look like you're both on the same stage versus you being in control. So show the jury and the judge that you're always in control through your cross-examination. Tips for preparing your witness for cross-examination. And what this means is, if I have a witness in a, let's just say, a criminal case, and the witness maybe is Jane Doe, one of the very first things that I tell every person that I'm talking to when it comes to preparing for trial is what matters most is that you tell the truth. No matter what I say, no matter what anybody else says, all I want you to do is tell the truth. And why that's helpful is one of the first questions that Jane Doe is going to get from the defense attorney is, you met with Mr. Adams in this case, didn't you? Yes, I did. You met with Mr. Adams over 2 times? Yes. Did you meet with him over 5 times? Yes. And then the defense attorney will commonly do an open-ended question and say, what did he tell you to do today? He told me to tell the truth, and that's your best way, because defense attorneys want to show to a jury that you've met with the prosecutor a number of times or the advocate so many times that at this point in time, you're only speaking about what they told you to say. And your job is to make sure your witness always knows that all you're asking them to do is to tell the truth. Having your witness be prepared to not be afraid to ask questions to the attorney. I don't understand your question. Will you please repeat it? Is a good one. If you don't understand the question, do not answer yes or no until you understand what that question is. In other words, you're kind of helping your witness be prepared for having control as well as to how they answer questions and when they answer those questions, and to not feel pressured that they have to answer them if they do not know the answer. If you do not know the answer, you do not know, and you testify accordingly. And if you do not remember, you tell them do not recall, and then that's the attorney's job to refresh the memory of the witness.
Yeah,
Truthful,
I want to piggyback on you on this. At least being an East Coast Jewish person, we were taught at a young age to be uncomfortable with silence. And so we fill in the blanks with chitter chatter. about things that we only halfway know about. And the courtroom is not the place for a conversation. And one of the mistakes that I see witnesses make the most is to start walking out on a thin branch, trying to fudge something that they kind of know but don't remember, or don't remember and feel embarrassed that they don't know. And they start filling in blanks with things that are not bricks of truth. And it's never ends well.
Yep.
So being honest about what you know and what you don't know, what you remember and what you don't remember, is key. The other thing I will try to say that's not on this slide, yeah, and don't try and hide embarrassing facts. I had one of these the other day, where an attorney was asking a silly question. They were trying to cast credibility issues because the parties had another case going on, but it was unrelated. And the witness started to fudge over that there was this other case, which there is. And I was like, what are you doing? Because she had given about 25 minutes of powerful testimony and then started kicking dirt and fudge over this other thing. And she turned into an uncredible or incredible witness. And all the important things that she actually did have to say were sacrificed on the altar of bullcrap. So don't fudge it, is my advice. And the other piece, David, and then I'll shut up, is a practice tip that cross-exam for your witness, your client, is like a proctal exam, which is an exam of your tuchus, in case you're not, familiar with the word proctal. And if you don't know the word tuchus, I can't help you. But nobody wants their tuchus examined, okay? Nobody that I'm aware of. Maybe some people do, but they have to meet with their therapist about that. It's an uncomfortable experience being cross-examined. And so woe to us as advocates if we don't prepare our client for that proctal exam on the record, sitting in a chair, with helping them to be psychologically, spiritually, if you dare, emotionally prepared for this highly uncomfortable experience. Because if they lose it on the stand, or lose their cool, or allow that opposing counsel to trigger them, it doesn't end well. I'll subtly understate it. So helping your client have touchstones for comfort, teaching them the 25 breaths that you talk about, their own little black book, whether it's a stone from a place that it's meaningful to them, or a picture of their child. This is not legal advice I'm giving you. This is advice to try to help your client survive with dignity and grace a very difficult experience, and that's being cross-examined.
Excellent advice, Judge. And I think the extra layer to that is having uncomfortable conversations with your client. And when you're doing this, it's being a human being as well, because you always have to remember that the questions that are going to be posed by defense counsel especially are not meant to make your Jane Doe happy. They're not meant to bolster their self-esteem. They're not meant to put them in a place where they seem credible. They're meant to tear them down in every way possible. And I always tell every Jane Doe, or John Doe for that matter, that this is going to be one of the most unpleasant experiences of your life, because this is the most traumatic thing that has ever happened to you, and somebody's going to be making you out to be a liar. And you have to remember, they're not there to help you, and you keeping your cool about this and being as calm and professional, be emotional about it, show your emotions. That's okay, because a lot of times those emotions are powerful and they are tearful, but don't let them get you. And so then I say to them, and I really apologize beforehand, but I'm going to give you some examples as to how this is going to play out. And I want you to know this isn't something I believe, nor do I think it's even relevant towards what's happened, because what happened is all that matters. How much you drank that night and why you drank that much tonight, they don't matter, you know? And so you prepare them and you really go through that process of having a heart-to-heart conversation. And as we all know, multiple interviews can trigger post-traumatic stress. And so to be equipped for that time in the process, but you do have to do it with somebody so they know how it's going to be. And then you go through all of those hard questions.
Right. I always apologize to them. I say, I am not doing this. I'm doing this as a friend, actually, that I'm going to slowly vaccinate you for what's to come. And so I'm going to ask you hard questions. I'm going to pretend I'm the other attorney. Please know this is not me, but part of my job to get you ready for this is to do this. And cross-examining your client as practice is invaluable. It's uncomfortable, it's not fun, and you can find your good bedside manner to explain to them why this is important and why you're doing it. And you're not taking pleasure in it, but you have to get them ready. Because if they're not, indeed, one of the tactics of cross-exam is to trigger you so that you lose it. And now the judge thinks you're a hot mess and doesn't need to believe what you say. And so this vaccination process of practicing with them is very important.
And in addition to that is, you know, don't be afraid of the bad facts. And I say that lightly to the extent that, of course, you need to be cognizant of them, and but you don't want to hide them. And you have opportunities to get those bad facts out through direct examination. You have the opportunity to correct those bad facts in closing. You have an opportunity to talk about them in opening if you're going to be confident that you're going to be talking about it through witnesses or evidence. But don't wait for the defense to do it, because then it seems powerful. Be proactive and get it out there first, and so it's not a big surprise, which is why truthfulness and honesty is everything, because you will have to ask questions about the past that might not seem completely relevant to the current situation. But if somebody sent in a letter to somebody else accusing them of rape, and your client doesn't tell you about that, and that letter ended up being a hoax, and it comes out at trial, that this person has done this before, and you didn't know about it, and it jeopardizes their credibility, then all of a sudden you're sitting there not feeling so good about your case and how strongly their credibility was attacked by the defense in a situation. So you have to ask your client all those questions too, that are tough questions, that you have to remember that somebody with a badge can go to the reservation or anywhere for that matter, and they can go to a witness and they can pull out that badge and they can say, hey, I'm FDI, I work for the federal government. And all of that can be true. And then think about that. Did I say FDI or FBI? What is FDI? Do I even ask them what that means? Oh, they work for the federal government. That's all that matters. That's scary. Oh, it's a federal defense investigator. They're not here to help me. They're here to help the defendant. What are they going to do? They're going to turn on a tape recorder. They start recording information, and you're going to spit out a lot of stuff. And all of that's going to be used against you at some point, because they're going to be using leading questions in this, defense interview tactic that can be used, and it can be confusing and misleading. So just being prepared and preparing your witness / Jane Doe for all of that is crucial to protecting the integrity of your case. Tips for, my screen just went blank. Tips for preparing your witness for cross-examination. Great tip that we have not mentioned yet is that you do not want your witness or victim in the case to be having a conversation with other parties regarding their testimony. You want to protect the integrity of that testimony. You do not want that to be something that they discuss, especially with other witnesses. A good defense attorney will find that out and they will use it against you. Answer out loud. In other words, don't use the nodding of your head, shaking your head yes or no, because then somebody's going to tell you to use words to answer the question, to be respectful and courteous, even if you do not. I think that if you can have a witness be more courteous than the actual defense attorney is being, and I say defense attorney, I'm only saying that because some of you will be defense advocates as well, and that is commendable and totally honorable, because protecting people's rights is crucial to this process. But we're talking a lot from a plaintiff perspective here. If an attorney objects to a question, stop talking and let the judge rule before you answer. In other words, if you hear an objection, that means you got to stop. The judge will then decide when and if you can answer that particular question. Beware the "have you told me everything" question. Tell the truth. And I think ultimately ends with that. Tell the truth. We've got 1 minute, Judge. I don't know if you want to add anything to this.
No.
Judge V, you're a judge in Alaska, is that correct?
I am.
And you've been a judge in Alaska for more than 5 years?
I think I'm coming up on my 15th anniversary.
And Judge, in addition to being a judge, you're also a faculty / trainer / occasional whatever. You train occasionally, and you also present at conferences. Is that correct?
That's what they tell me. I show up where I'm told.
Are you sympathetic, Judge, to issues pertaining to the Violence Against Women's Act?
Big time. We're on the front lines in Alaska, in rural Village, Alaska. And I'm grateful that the protective orders I can issue from tribal court are respected and recognized and enforced in all 50 states and territories.
So it's fair to say that you're sympathetic to issues regarding domestic violence as well. Is that correct? Yes or no?
Oh, wait a minute. Are you cross-examining me? Damn it.
And then the last question was going to be, but Judge, you don't have any bias, do you?
Oh, man.
That was our quick little cross.
He got me. He got me.
And so we will. This was a good one. This was a lot of fun, and it really is an honor to do this with you, Judge. It's fun to present with you, and we did it in exactly perfect time. And so I'm going to say goodbye until next time, and thank you for your time. And Judge,
thank you. That's a wrap.